Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I was requested to do a video on this 2012 decision from the District Court of Minnesota. It's the Zortman versus J.C. Christensen and Associates. And this has to do with, is it a violation of the FDCPA, the Fair Debt Collection Practices Act, to leave a voicemail on the consumer's phone where you do not identify the consumer and you do not identify exactly what the debt is. And there's been some controversy over that. And this decision, it's a pretty lengthy decision, so this video will take a while, but it will really go in depth as to at least this judge's position. Now, I'll tell you this, I have not dealt with this case before because I don't think it has any application where I typically practice, which is the 11th Circuit. So that's the circuit that covers Alabama, Georgia, Florida. We have an 11th Circuit case that this decision, the Zortman decision, will actually reference that I think guts this argument by the debt collector. And the 11th Circuit would reach a different decision than this particular judge reached. So I don't agree with the conclusion in this case, but it's important to understand where the judge is coming from and to understand the judge's reasoning and logic here. Okay, so let's get started in it. So this debt collector calls the cell phone of the plaintiff, the consumer, leaves a message, identified itself as a debt collector. Now she had loaned her phone to her kids and they heard the message. So she sues and they file a motion for summary judgment. So this is after discovery. This is saying, look at the facts and it's just undisputed that we would win. Now, before we really get to the merits of it, and we're not going to spend a whole lot of time on this, but the debt collector argues the case is moot. And we'll see exactly what that is. It's an argument we don't see too often anymore, but for a while it was kind of all the rage among debt collection defense lawyers. And then they say, well, even if the case is not moot, then we did not violate the FDCPA because we were following the requirements of the law. And if you hold to a contrary interpretation, that means we can't even use voicemail. Basically, we can't even make telephone calls, so that's absurd. All right, so here we go. The facts, as known after discovery, show debt collector's message contained only the minimum disclosure requirements, and there's no factual dispute. So a lot of times in summary judgment, we have factual disputes. So I was just at a summary judgment argument, and I was making the point to the judge, look, we have a factual dispute. A jury has to figure this out, and the judge agreed. But sometimes we don't have factual disputes. It's just who is right on the law. Now here's this thing with the argument by the debt collector that this is moot. The lawsuit is moot. So they made, this is Federal Rules Civil Procedure 68, offer of judgment that was rejected, and is for $1,001 plus costs and fees through the date of the offer. Now, let me just tell you what an offer of judgment is, since the judge brings it up here, and then we'll look at the facts. An offer of judgment is where the defendant says, I offer you to take a judgment against me for this amount of money, and in this particular case, it's $1,001. The reason is because the statutory damages, if you can't prove any actual damages, statutory damages are capped at $1,000 total for the case. So they threw in an extra dollar just to be safe. And they're saying you can't get emotional distress or anything else. And then they say, plus we'll give you costs and fees, attorney's fees, through the date of the offer. So we'll come back to that in a moment. So here are the basic facts. The consumer, ironically, is an employee of a debt collector. And this account's a Kohl's department store, gets turned over to JCC. They call the numbers they have. And here's the message. It is, we have an important message from the J.C. Christensen. This is a call from a debt collector. Please call this number. So it does not identify anything specifically about a debt, and it does not identify the consumer, but it does identify the debt collector, and it identifies this is a call from a debt collector. So the consumer's practice was to give her cell phone to her kids when they were out. They listened to the voicemail and then they asked her about it. She says, hey, we're in financial trouble. And she says, I had emotional distress, loss of sleep. Now, remember that Rule 68 offer of judgment? The defendant is basically saying, look, we gave you everything you're entitled to, so there's no longer a case or controversy, so there's no longer any subject matter jurisdiction in this court. Now, the court disagrees and says, no, I do have jurisdiction. So Rule 68A says if the plaintiff rejects the offer and the judgment the plaintiff ultimately attains is less than the unaccepted offer, they have to pay the cost incurred after the offer was made. And the whole point of this is to encourage settlements. And then the judge says, look, my jurisdiction is limited to cases and controversy. So we don't do kind of advisory opinions. You can't go to a federal judge and say, hey, what do you think if X, Y, and Z happen? And then the judge just gives his or her opinion on that. That's not what we do in federal court. So absent actual case or controversy, court lacks subject matter jurisdiction and that must dismiss the case. Plaintiff bears a burden of proving their subject matter jurisdiction, and the case becomes moot when a party no longer has a personal stake. And so some courts have said if you get an offer of judgment that gives you everything, then there's no more case because you got everything you were entitled to. So if I sue for $10,000 and the defendant says, take a judgment against me for $10,000, and I say, no, I want to keep going. Well, why? Because I got exactly what I wanted, the $10,000. So here's the argument that the debt collector makes. It says it's all the damages that you're entitled to because you cannot get emotional distress damages. Here's the little hint. Debt collectors always say this. I mean, I can't tell you how many of these that I received back when these were sort of popular to send out. And I would have some lawyer that would send me this Rule 68 offer of judgment. And then they'd send this, sort of condescending letter to me. Well, John, it's clear that you cannot get emotional distress damages. Or they might even include some and they say, there's no way you can ever get more emotional distress damages than what we provided. Now, I'm going off on a slight tangent here. But what amazed me is the lawyers sending me these had never once stood in front of a jury, had never looked a federal jury in the eye and asked for damages or asked that the consumer not be awarded damages. Now, they just went to these seminars and they stood around and held hands with other debt collection defense lawyers and said, oh, we have just figured out that there's no way a jury would ever award any money. And my law partner and I just kind of get these and laugh and say, we've stood in front of federal juries. We've had to look federal jurors in the eye and ask for money. And we have repeatedly received emotional distress damage awards in the six-figure range. So when I have these lawyers that have never been in a federal jury on an FDCPA case, and they sit there and go, oh, well, I've figured out in my own mind that there's no way a consumer lawyer, a personal injury lawyer could ever get emotional distress damages. It just blows me away. And look, I've been doing this for 25 years, which doesn't mean I'm any good. But what it does mean is for 25 years, we have been asking for emotional distress damages in personal injury cases and fraud cases, all sorts of cases. And so it just amuses me that these lawyers that don't have any idea what they're talking about will just be so arrogant about this. They say, well, John, I served you this offer of judgment. There's no way you can get more than X number of dollars in emotional distress. And so now your case has to go away. And we just laugh at them and, throw that in the garbage. So anyway, going back to this, I'll step off my soapbox here. At least for a moment, I'll step off of it. So the debt collector says, look, you can't get emotional distress damages. She says, yes, I can get emotional distress damages. And you messed up the Rule 68 offer because you did not include post-offer fees. So remember, the offer said your fees incurred up to the time the offer was served. Well, here's the problem for the debt collector so it doesn't specify the amount of fees. So even if the consumer accepts it, Well, how do you know what the amount of fees is? Well, a lot of times there's going to be a fee battle. Well, the law says that we can recover fees while having that fee battle. So when they try to cut you off on the date of the offer, so they send this to you on August, 23rd, 2020, and they say you don't get any more fees after that. Well, that's not a valid offer, so we can ignore it. And that's ultimately what happens here. The court says, I agree with you on that. At least when you get the offer, you're allowed to talk to your client and incur some fees. So I'm not even going to reach emotional distress argument. We're not going to look really anymore at this. It's kind of a technical thing. And the judge says, well, let me just back up to here. Although fees accumulated after the offer of judgment are likely minimal, that's only true if everybody agrees to the fees. Okay. And trust me, we've had these where they serve an offer of judgment, we accept it, and then they go, oh no, we think you should have some tiny amount of fees. And now, of course, they think it's okay for them to have 50,000 in fees, but we should only have 10. And we say, no, actually, we have like 75,000 in fees. But anyway, the judge says here, those fees after the offer of judgment nevertheless prevent the Rule 68 offer from encompassing all of the relief. All right, so let's get to the real part here. The consumer, and I put this actually in the wrong color here, but the consumer alleges a voicemail message left by JCC violated 1692CB, okay? And so now the court's going to look at some of the statutory interpretation. We had a recent case where it was in the context of 1692G, where it went through a really in-depth analysis of statutory interpretation. So we'll put a link to that. It should be up in this video. And this will be very similar and familiar to you if you have watched that previous video. It says, with any question, a statutory interpretation, you begin with the plain language. And the judge says FDCPA is silent on the availability of voicemail messages. And so that's ambiguity. Now, I disagree with the judge. I don't think there's anything ambiguous. The FDCPA does not have to define voicemail messages or email messages or text messages or Facebook messages. It just defines communication. That's all it has to define. So I think the judge, with good intentions, goes down the wrong path here. And so the judge says, because I think there's ambiguity, courts should consider legislative history and other authorities to determine the intent. And then the judge correctly points out technology has changed a lot since 1977 when this was passed. You really didn't have voicemail back then. And points out the FTC does talk about telephone operators, telegraph clerks, and it says allows contact by a debt collector if the only information given is that necessary to enable the collector to transmit the message to or make contact with the consumer. And so the judge reasons from that it must be okay to be able to transmit messages to consumers. And then the court points out that collectors, consumers, and courts have struggled to interpret the FDCPA and harmonize different sections of it, and we'll see that here. And so this really focuses on the interplay between the Act's requirements that they meaningfully identify themselves and the prohibition against communicating with third parties. So those sometimes can appear to be at odds with each other. So how do you harmonize them? And then it gives us a little background. For many years, debt collectors did not identify themselves on voicemail messages. And the debt collector explains that's because they did not want to run into liability under 1692CB. And that basically says don't communicate in connection with the collection of any debt with any person other than the consumer. Okay, so we've talked about this in other videos. A third party is anybody other than the consumer's spouse, or the consumer's lawyer. So the consumer's kids, third party. Consumer's parents, third parties. Neighbors, third parties. The preacher, the priest, the rabbi, third parties. Okay. And the judge points out once a message is left, whoever left that message has no control over who might listen to it. And so messages that contained information about the named consumer's debt could be heard by individuals other than the intended consumer. But this started changing when courts started imposing liability on debt collectors for failing to comply with two other sections. So we looked up here at 1692CB, but a debt collector also has to follow 1692D6 and 1692E11. So the D6 says you cannot place a telephone call without meaningful disclosure of a caller's identity, the caller being the debt collection company. E11 says a debt collector may not use any false, deceptive, or misleading representation, which includes failure to disclose in subsequent communications that the communication is from a debt collector. Now, it also says the initial communication, you have to say, this is an attempt to collect the debt, any information be used for that purpose. That's called the mini Miranda. But even every voicemail after that, or every communication after that, you have to disclose that it's from a debt collector. So how do you put all these things together? So it started in 2005, but really it was a decision that I have here in red called FODE versus NCO. And those said, hey, debt collectors, you're violating the law when you do not identify yourself and identify yourself as a debt collector. So what did debt collectors do? So they said, well, wait a minute. If we identify ourselves, then we avoid liability under D6. Remember, that's meaningful identification. And E11, this is from a debt collector. But it puts us in liability for 1692CB because now we've communicated with third party if anybody else overhears it. And the court correctly says that's almost universally rejected. And so the courts look at the debt collectors. They say, hey, we're between a rock and a hard place. We're in a Morton's Fork, a Hobson's Choice, a Catch-22. They have all these clever names for it. And the courts say, you're wrong, okay? You're just wrong on that. And the judge says, well, sometimes when the courts are doing that, they talk about 1692CB, which is what we're talking about in this particular case, in the form of dictum. So dictum or dicta is just something that's not necessary to decide the case. So a judge may say, well, we rule that, for example, let's take a car wreck case, that the plaintiff did not prove wantonness or recklessness. But even if you had proved it, we'll just go ahead and give you our opinion about what that would mean. Well, that's dicta because that wasn't really before the court. Once the court said there's no recklessness or wantonness, that should be the end of it. And so that's what the judge in the Zortman decision is saying. And some courts have observed, again in dictum, that 1692CB only applied to purposeful communications. So it has to be deliberate. Other courts have observed that if they cannot comply with all sections, they simply cannot leave voicemail message. This is what my circuit says. So I have this in red, the Edwards versus Niagara Credit Solutions. Here's the quote. It's a great quote, and I'll probably do a decision or a video on this decision because it's pretty interesting the way the court analyzes this. In the 11th Circuit, which again is Alabama, Georgia, Florida, if the debt collector's assumption is correct that, well, we have to violate one section to uphold the other, the answer is that the FDCPA does not guarantee a collector the right to leave answering machine message. Pretty simple. So I just want you to visualize that you have all these debt collectors that are just like wringing their hands and crying and weeping and gnashing of teeth saying, this is so unfair. I mean, we either have to violate this section when we leave a voicemail or we violate this other section. And the 11th Circuit is saying to them, hey, boys, just don't leave a voicemail message. If you're going to violate one section, no matter what you do, just don't leave a voicemail message. And it's like the collectors go, well, I can't accept that. I have a God-given right to leave a voicemail message. No, you don't. You don't have any God-given right to leave a voicemail message. So here's another one. If you cannot simultaneously comply with multiple applicable provisions of the FDCPA, so now I've left the offending messages. And so going back to our court here, statutory language of D6, remember meaningful identification, E11, hey, I'm a debt collector, requires debt collectors to meaningfully identify themselves and state that they're calling to collect a debt. sometimes referred to as a mini Miranda, communications with the consumer. And 1692CB does nothing to eliminate that. Okay, so we all agree with that. So what do the debt collectors do? So they began leaving messages that contained meaningful disclosure of their identity, and consumers started suing them for 1692CB. And so then these debt collectors, again, start making these, hey, we're between a rock and a hard place, and those get rejected. Here's a case from where I practice, which is Alabama. It's my case from a decade ago, Leahy versus Franklin Collection. And again, we made that argument that, hey, you have no God-given right to leave a voicemail message. And the debt collector saying, well, we should be able to violate one section to avoid violating. No, you just don't violate any sections. It's pretty simple, actually. Just don't violate any sections. And so then this other case, following the reasoning and Fody, that's a 2006 New York case, finding debt collectors not entitled to leave. So that should be the end of it, but this court says, well, I think there's something that is different about the facts of the case in front of me than all these other cases. The courts have faced almost exclusively with voicemail messages that did more than merely identify the caller. They also identified the intended recipient. And they revealed that the recipient owed to death or both. And those violate 1692CB. And I'll have a link to this decision so you can read it for yourself. Like here again is the case that I handled. This is an attempt to collect the debt in the message. And the judge says, well, that makes it different. A mini Miranda message would disclose a consumer's debt if given to a third party. And so the debt collector could not have known for certain who would ultimately listen. And so that's why the messages in this present case just say, we have an important message from J.C. Christensen. This is a call from a debt collector. Please call us at this number. And so the collector says, hey, we can't be liable for violating 1692CB because we did what this previous case told us to do. And judge says, no. They didn't tell you that you wouldn't violate this section CB. They just said that you want to avoid violating D6 and E11. Observations about CB in those cases is dictum, and courts have opined ad nauseum that the FDCPA might not permit the use of voicemail at all. So again, think about that 11th Circuit case. And then the court says, well, now let's look and see, does this actually constitute a third-party communication? Now, I think where the mistake the court makes is just not looking at the definition in the FDCPA, because now the court's going to start looking at the aim and the purpose and the intent. And I think that's going to lead the court astray a little bit here. So one aim of the FDCPA is protect consumers' privacy. So in the Senate report, it talks about disclosing a consumer's personal affairs, friends, neighbors, or an employer, which is absolutely wrong. I mean, when I say it's wrong, that's illegal to do that. And then the judge says, well, look, postcards are off limits because, you would lose your privacy. But deliberate communication with third parties is not completely forbidden because you may seek location information. And we've talked about that in other videos. Location information is the consumer's name, address, phone number, and where they work. Okay, so place of employment. And then the court says, but what about third-party communication that is not deliberate? Well, the FDCPA is strict liability, so it doesn't matter about your intent. And now the court will, in a footnote, explain intent comes into play with a defense that debt collectors often make, which is called bona fide error. So we'll look at that later. Recognizing difficult, though perhaps not impossible, challenge of complying simultaneously with all sections of the FDCPA, they've employed various techniques. And so we'll look at some of these. So what they say, if you're not the person requested, disconnect this recording now. And then there'll be a delay. And then the substantive message will be left. And they say, but of course the debt collector has no assurance or even maybe reasonable expectation that the person listening would obey. Now we'll point out the judge says spouse. A spouse is not a third party. The consumer is, when we say consumer, when we're talking about a third party disclosure, consumer means the consumer, the consumer's spouse, the consumer's attorney. So this part is actually not correct, but his point is made, I think, correctly here, that he's saying, look, when you leave that kind of message, you don't know that the person listening is going to actually obey you, and they have no obligation to obey you. And then at the other end of the information conveying spectrum, other debt collectors have simply hung up without leaving any message at all. And then we have some suits over, what about debt collectors that block their number, put a misleading name? It's kind of all over the board, at least at the time this is written. And the court says, at least in the District of Minnesota, there has been liability found where phone calls were not answered, no message was left. There, the debt collector allowed false caller ID to appear, and that violates 1692 D6. Remember, D6 is meaningful disclosure of your identity. So if you put some bogus thing on the caller ID, that's not meaningful disclosure. And then let's go down to here. So the court says, we start to see where the judge is having a problem with the consumer's theory. It says, look, just having the caller ID, you can do a reverse telephone directory internet source to figure out, hey, this is a debt collector that's calling. So I don't think this is right, but this is the assumption that the judge makes, and everything is built on this. And it makes sense if this assumption is correct, but I think that it is incorrect. Thus, even if a consumer had no voice messaging system, the mere existence of a missed call on her cell phone log would reveal essentially the same information, the identity of the debt collector and his phone number. Well, I don't think that that's correct. Okay, there's a difference in getting a missed call and having a voicemail where somebody is leaving that message to you on your cell phone. Okay, and we'll see the judge going to say, well, they don't mention the consumer's name. Well, but you're leaving it on the consumer's cell phone. Okay, and obviously you're trying to get the message to the person that owns that cell phone. So here we go. Courts of the opinion message left in this case most productively analyzed in terms of whether the message was a communication for purposes of 1692 CB. So what's a communication? Well, we go back to 1692A. We have a whole series of videos on the FDCPA, every section of the FDCPA. And I really encourage you, particularly lawyers watching this and consumers who are interested in, hey, did somebody violate the law? Can I sue? What's the deal? You start with the statute itself. Let the statute define what these words mean. We don't have to guess what communication means. Communication is the conveying of information regarding a debt directly or indirectly to any person through any medium. So when we hear debt collectors or judges say, yeah, but they didn't have Facebook Messenger or direct messages under Twitter or email or voicemail. Well, any person through any medium. What does any medium mean? It means any possible way to transmit information. That's what it means. It doesn't mean anything less than that. It means exactly what it says, any medium. Courts have taken an extremely broad view of indirect communication. So a message whose purpose was to induce the consumer to return the call, hey, that qualifies. Leaving a live message with third party, it's very important, but not mentioning a debt or that the caller was debt collector, that's communication. Absolutely. I mean, it literally is what it says. If you do anything, directly or indirectly, that, let's go back to the definition, to any person through any medium that conveys information regarding a debt. Okay? And so it's a very, very broad view here. So here's the consumer. What happened is the judge was not satisfied with the arguments made by the parties. They kind of went down a different path that he wasn't particularly interested in. And so the judge says, give me some supplemental arguments here. So the consumer says, well, look, by the fact that it says important, that means it's about a debt. And compares the situation to other sections where mere identification as a debt collector is prohibited. So this B5, so it's language or symbol in the mail. So in other words, if you get a letter from Midland Collection or Portfolio Recovery and it has on there, attempt to collect a debt by debt collector, well, that would violate the law. And says, here's same thing, this F8 about language on the envelope, and then citing to Fody, that's a 2006 New York case. So the debt collector says, well, we didn't disclose that a particular consumer actually owed the debt. And a mere statement identifying a caller as debt collector may not be sufficient. So it cites this Marks versus General Revenue, 10th Circuit, came out about 9 years ago. I think this is, just to be blunt, I think the court really missed this case. But, I'm not sitting on that court. And here's a fax requesting employment information verification did not convey information regarding a debt, but also noting sender's name and logo did not make explicit the request was from a debt collector. Again, I think that's absolutely wrong, and I don't think that at least the courts that I practice in front of would follow that approach. Okay, so then here's another one. Applying a call that merely identified the caller was insufficient. Here's a weird one. Message left with third party stating the plaintiff's wife's being foreclosed on when he'd never been married did not constitute a communication regarding a debt owed by the plaintiff. So almost seems like it's encouraging the debt collector to lie about it and then say, see, that wasn't a communication. Ultimately, the court says, I don't really find anything that anybody gave me to be particularly helpful, and rejects the consumer's claims because this isn't an envelope, and the envelope would mention your name. Now, there are some envelopes that don't. They say to current resident. And the likelihood of third-party viewing an envelope sent through the mail is much greater than overhearing a voicemail. Well, maybe, maybe not. I think that's an assumption there. And the court rejects the cases cited by the debt collector as well. So here's how the judge is going to look at it. And judge says two assumptions that the third-party listener would need to make. And give me just one moment, get some water. Okay, so two key inferences. And remember, the collection messages were not directed to the consumer by name. So anyone listening to a message would not be told that it's a consumer. Excuse me. It says, now you'd have to make the assumption that because it was the consumer's telephone, she was the intended recipient. With all due respect, I think that's the assumption almost everybody would make. It's sort of like, you get a text message on your cell phone. If you saw somebody get a text message on their cell phone, you would assume the text message was to the person that has the cell phone. Same thing with a voicemail. So I think this argument, the judge missed it here. And judge says, well, look, it could be wrong number. And if you listen to that voicemail, you couldn't tell whether it was a wrong number or not. I just think the judge is wrong on that. Unintended listener would then have to make a second assumption that the only reason a debt collector calls is to collect a debt. Well, they also call to obtain location information. But here's the thing. You only say this is an attempt to collect a debt when you're collecting a debt. You only say, hey, this is a call from a debt collector when you're in the midst of or in the process of collecting a debt. So in other words, if you do location information, so you're trying to collect a debt against me, and you call my neighbor and you say, hey, I'm trying to get location information for John Watts. Can you verify his address, his phone number, and where he works? You don't say, and by the way, I'm a debt collector. Okay, you absolutely cannot say that. So again, the second assumption, I think the judge is mistaken on this. Matter of fact, the only reason a debt collector calls is to collect a debt when they say this is a call from a debt collector. Now, judge makes the argument that, thought this was kind of strange. The consumer worked for a debt collector, so it'd not be unreasonable that a call from a debt collector related to her employment. I'm just imagining if I work for a debt collector, I work for Portfolio Recovery Associates, and they call me to say, hey, can you work an extra shift on Saturday? By the way, this is from a debt collector. They won't tell me that. They're not collecting a debt from me. I just think the judge missed it. I understand the thought and the sort of the reasoning, but these are just wrong assumptions in my view. So going back to the opinion, the collector's messages in contrast found to messages that have been found to be violations in other cases like the Leahy case and other cases that we've already talked about. And the word important doesn't matter. I think that that's correct. Important doesn't mean anything. I mean, just either this is in connection with collecting a debt and it's a communication, or it's not. Whether they say important, unimportant, mildly important, that doesn't matter. So the court says, I conclude that the messages left by the debt collector on the consumer's voicemail do not constitute communications with a person other than the consumer. And the judge says, be unreasonable to constrict commercial speech so that voicemail message that essentially reveals no more than a hang-up call. Again, I think that's an assumption that's wrong. But this is the judge's argument. Triggers liability for communicating with the third party. Where courts have found messages be communications under the FDCPA, they conveyed more information than would be available from a hang-up or a missed call. And some courts have found communication requires message be received. Okay. And I guess the argument here is that, I mean, like this is sort of common sense. A letter that is mailed but never received is not a communication. I agree with that. And now the question is, if you call and you leave a voicemail, well, certainly the communication has been received. What if you call and don't leave a voicemail message? Well, you may be leaving that sort of missed call as a communication. And we obviously do that in everyday life, right? You know, we'll call our best friend and we may not leave a voicemail. We're like, oh, you know, he'll see my call, my missed call, and call me back. So it does communicate something. And but it's not the same as an actual voicemail that says, hey, we got something really important. This is the name of, you know, my debt collection company and I'm a debt collector. I think that conveys a little bit more than just a missed call. And one court recognized communicating is I don't even remember that from English class, intransitive verb. Okay, apparently that means to transmit information, thought, or feeling so that it is satisfactorily received or understood. A message that conveys no more information than a hang-up call shall not be construed as a third-party communication. And then the judge says, here are some practical reasons. It would effectively remove the telephone as a means of communication, and the telephone is allowed. Well, again, there's an assumption being made that a missed call can get a debt collector sued. And that since that shouldn't be the case, then just leaving the same information as you, in essence, would get from a missed call should not get the debt collector sued. Well, again, we've got multiple levels of assumptions there that I think are incorrect. And it'd be essentially impossible to use a telephone without conveying the same information as a voicemail is conveyed. Well, again, remember that 11th Circuit case that talks about you can't violate one section to not violate another. You just shouldn't violate any of them. So if it maybe because of modern technology, because of caller ID, if you can't even do a missed call, then guess what? Don't do any calls, okay? Or block your caller ID, but make sure that you're not running afoul of that meaningful identification of who you are as a debt collector. So we'll see I'll do a follow-up case to this about why I think the court has kind of gone down the wrong path. But let's go back to what the judge is saying here. I don't think it'd be a fair reading of the act, would not advance consumer interest. And to follow up with that, the judge says, look, consumer has an interest to know who is calling. I'll be honest, first time I've ever seen this in an opinion. Quoting from Emily Post Etiquette. When the call is answered, state your name. It's polite, even when you're talking with a family member, a close friend who knows your voice. You know, never thought I would see that in an opinion, but there it is. All right, consumers might reasonably consider incessant anonymous calls be harassing. And then the judge says, but you know, it's amazing how many times you can call somebody and not get sued. Finding 114 calls in a 4-month period not violate the FDCPA. And that's true, that's what the case says, at least I assume it is. But I can tell you that, you know, there's a difference in calling twice a day for what's 4 months. That's 120 days. This is less than once a day. Okay. But let's just assume it was twice a day. Well, twice a day for 100 days is 200 calls. That's different than 50 calls over 4 straight days. Okay. And the FDCPA says you cannot make so many calls that it's harassing. And then judges are saying you can get a bunch of calls. So this is an argument apparently for why it's good for a consumer to be able to find out who's actually calling. So a judge is saying, I want debt collectors to leave voicemail messages because the consumer might send a cease and desist letter. And we have videos talking about the cease and desist letter. And a debt collector can hardly use telephone at all, and requiring hang-up calls or blocked identification is tantamount to that if it's stymied from learning whether the consumer it seeks wants to communicate with it. And the judge says third-party communication is in harmony with stated purpose of the act, legislative intent. Again, I think the problem is we never get to that, legislative intent and harmonizing when the plain text gives us the answer. And so for the reasons stated, interpreting 1692CB prohibit voicemail messages that merely identify a caller's debt collector, leave a return phone number does not favor the consumer, and that would be a bizarre result. The message did not identify a consumer, did not identify a debt. It's basically the same as caller ID, and so the debt collector wins. Summary judgment's granted. And so here's a footnote, and this is important to look at because oftentimes, at least by inexperienced defense counsel, debt collectors will assert this bona fide error defense. And here's what it says. A debt collector may not be liable in any action if the debt collector shows that the violation was not intentional and resulted from a bona fide error, notwithstanding the maintenance of procedures reasonably adapted to avoid such error. So it can't be intentional, and you have to have procedures that are adapted to avoid that error, not just errors in general. So we'll have these guys come in and they'll say, bona fide error. We go, well, what's your procedure? It says in our policy manual, do not violate the FDCPA. We're like, does it specifically identify false credit reporting or calling neighbors or filing a bogus lawsuit? They're like, no. It just says don't violate the FDCPA. So we're good. So you'll dismiss your case, right? I'm like, no. Okay. It's got to be specific. And the 11th Circuit in the case, this Edwards case, says, look, whether debt collector is entitled to defense when it intentionally violates one section, that's at E11, in order to avoid the risk of violating another provision. So in that one, they did not identify themselves as a debt collector because they said, we don't want to violate 1692CB. Finding an intentional violation of E11 constituted a violation of good faith, bona fide error defense did not apply.